I said a couple of days ago, Earl Warren is the most liberal Supreme Court justice we've ever had. Sweeping changes, and they sometimes call it the civil rights case. And so I have these 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 cases that are vital to know. And so we're going to run through them real quick, and you're just going to fill in where they need to go, okay? Now, if you remember back in 1896, they ruled separate but equal was perfectly legal, so as long as it was 100% equal. Well, we know inherently it wasn't. So in 1954, a court case goes before the Supreme Court, and it ruled separate but equal in education was unconstitutional. This will be the beginning of the end of Jim Crow and segregation. Segregation is still legal to this point. It's simply did away with, as it says, in public schools. The name of this court case is Brown versus the Board. Now, the full long name is Brown versus the Board of Education of Topeka, Kansas. There's actually 6 separate cases, Brown being the lead one because we associate it with Linda Brown. And so that's a major thing there. Now, in 1961, we have something called the Old Dirty Woman case. Basically, they went into this woman's house, Dalry Map, see it right there in Cleveland, Ohio, and they found some stuff that was kind of dirty for an old woman. I'm not going to delve too much in that. She got upset, saying they didn't have the right to take that. And this is a major case because it says that evidence obtained without a warrant is not permissible in court. The name of the court case, you see it right there, is Mapp versus Ohio. Here's the thing basically about Mapp versus Ohio. Significant supporters of the Fourth Amendment claim that it is only a mint of. 3 officers searched it because they were searching a house because they thought somebody was there involved with a bomb, along with illegal betting equipment. I don't see where it said there. But basically they found some stuff there. Police failed to present a warrant for the search, which voided the admissibility of any incrimination, and that is the major thing of Mapp versus Ohio. The next one, prior to 1962, school prayer was mandatory in a lot of things, and so there was a guy named Mr. Engel, and he's going to sue a principal more or less named Mr. Vital. The way I remember this is Engel is the German word for angel. The name of the court case that outlawed mandatory school prayer is Engel versus Vital. So if you remember Engel, angel had something to do with it. There you go. Now in the 60s, the big thing going around was one man, one vote. I mean, that's the ultimate thing there. The name of this court case, as you can see there, is Baker versus Carr. And then also once you put Reynolds versus Sims. 2 cases really kind of went with this one man, one vote, Reynolds versus Sim, and then also Baker versus Carr. It outlawed gerrymandering, or drawing up districts to promote segregation and to make the votes count less. And so Baker versus Carr, if you remember, if you look at it, B and C, right? 2 letters of the alphabet, both the same amount of weight in it. Okay? I know that may be nuts, but there you go. Then, okay, and the whole idea was to get better voting rights. That was the big thing. That was the first push. Once we got segregation done, the first push was to get voting rights, and then lastly was to get economic equality. And we'll cover that in civil rights. There's Reynolds Sims. All right. The next thing, we talk about a professional kind of petty felon. He was always getting in trouble. His name was Mr. Gideon. And Gideon was being sued by Wainwright while he was going to jail. He decided to sue the guy Wainwright because he could not afford an attorney. And so this is right to counsel even if you cannot afford one. We've heard that on many TV shows that we want them to have a good lawyer. And the name of this court case is Gideon versus Wainwright. It is your right to have a guide, to have an attorney. That's the way I like to remember that one. Now, 1964, we have a major case going on here, and it is protection of the Fifth Amendment rights against self-incrimination, okay, or the fifth. All right. Basically, you have the right in court to plead the fifth. Now, the public perception is if you do that, you are perceived as guilty. The name of that court case is Malloy versus Hogan. 2 men, they're in trouble for stuff about betting. Mr. Hogan's basically going down with the ship. He's trying to take Mr. Malloy with him. Malloy pleads the fifth. They sentence him, then he goes, well, you can't use that simply because I said the Fifth. And that's true. If you plead the Fifth, they cannot incriminate you. Now, if they find evidence that proves beyond a shadow of a doubt they don't need your admission, just put more burden on the state, I guess. Now we get into the ones that people have heard about, right? Hopefully. The first one we have in 1964 was the right to counsel during priest questioning. This came from a guy named Mr. Danny Escobedo. He was arrested by the state of Illinois, and he sat down in a holding cell, whatever you want to call it, in a police room, and began to tell his entire story. He got to jail, and people said, well, you have the right to an attorney. He goes, well, I didn't know that. No one told me that. And so the big deal is now, if you'll see on TV shows, they'll get in the courtroom, or they'll get in jail, and they go, I'm not speaking till my attorney gets here. That's the precedent set by Escobedo versus Illinois. Basically, you have the right to counsel during police questioning. Okay? Then we have 1964 outlawed segregation in lodging or motel services. You can see the Heart of Atlanta Motel there, correct? And so this is the Heart of Atlanta Motel versus Georgia. And so basically they said Georgia was forcing it on them. They were trying to say we can admit whoever we want. Georgia said no, money is money, so you cannot segregate in lodging or motel services. Then, in 1965, a big thing comes up in the state of Connecticut. You can see there's Planned Parenthood Center there. Morality is in danger. The law isn't the law. Contraception was banned in the state of Connecticut, and a woman named Griswold, she'll be right here, decided that she wanted to sue about rights of women's privacy. This is a major landmark case because contraception is allowed. You cannot ban it. And also Planned Parenthood is allowed, and Planned Parenthood has to do with abortions and a case coming up in Roe versus Wade. So there's a major thing going on there. The name of this case is Griswold versus Connecticut. So there you go. Now, the big one everybody tends to know, in 1966, certain warnings must be administered during an arrest of a person. We have a guy named Mr. Miranda, and it basically says that if Mariska Hargitay here, or Stabler, or Benson come and arrest you, they must tell you the following things. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, the court will appoint one to you. That's the Miranda warnings, okay? The name of this court case is Miranda versus Arizona. Then we have a major thing set here, and this is an easy way to remember it because love shouldn't have a color line. The state of Virginia denied these two people here the right to marry. And so they went and sued the state of Virginia. It's called Loving versus Virginia in 1967. Basically said interracial marriage cannot be banned. It says the freedom to marry or not marry a person of another race resides within the individual and cannot be infringed or taken away by the state. So that is Loving versus Virginia, and that's an easy way to remember it because you're allowed to love whoever you wish. All right. Then, 1967, we have a major thing going on here. You can see the court case there, Katz versus Illinois. You can see he's in a public telephone booth, right? And you see the FBI is like right behind him. You must be informed you're being recorded if the tapes are going to be used in court. But basically, he used a public telephone and claimed that was privacy. And people said, no, you use something in public, you're allowed to use it. The name of this court case is, of course, Katz versus the U.S. So there you go. Now, the last two were things we looked at in class. They kind of have a little more meaning now. Brandenburg versus Ohio. In supporting even the Ku Klux Klan right to meet and speak, the First Amendment right was defended. Okay? The Ku Klux Klan, Mr. Brandenburg went and spoke. He inflamed some people. Inflammatory speech means setting on fire, if you can see up here, right? And it basically said that is part of the First Amendment. You cannot censor inflammatory speech so long as there are no threats made. The name of that court case is right here. It's Brandenburg versus Ohio. Okay? Now I move on to our last one. A boy named Mr. Tinker, a young man, I guess, went into his high school in 1969. Vietnam is raging at this point, and he wore the black armband you see there with the peace symbol. He was kicked out of school. The next day, 50 or 60 of his classmates show up with the same one. And so it's a major thing going on. Can you punish symbolic speech, like an armband or a T-shirt, etc.? And in Tinker vs. Des Moines, they said symbolic speech, including appeal, is part of the First Amendment. So no, you cannot take away their right to freedom of speech. So this is the largest ever expanding. Generally speaking, we have Supreme Court's rule. They either constrict or they expand. This is the largest expanding right Supreme Court ever. It expanded or added the following civil rights. It outlawed segregation, which had been a law for almost 60 years to this point. It brought up voting, redistricting, or malrepresentation under that. It brought up criminal procedure again, Fourth and Fifth Amendment due process, but people didn't know what that was. Now we do. Free speech, you have Brandenburg, you have Tinker, Griswold could also fall under that. We have separation of church and state in Eingold versus Vittel, and another one of Schempp versus the Abington School District, which outlawed Bible readings. There you go with that. Free exercise of religion is another thing. So yes, you have to separate it, but you're also allowed to do whatever you want as long as you don't force it on somebody else. A right to privacy. That would be our Griswold as well. Cruel and unusual punishment. Okay. And that's where we're at to that point. Now, the next thing we're going to talk about are the protests, because this is a big thing in the protest, understanding where you were. Alrighty?